Let me welcome everyone here, and let me thank you on behalf of the Provost and Senior Vice President, Dr. Wayne, Dr. Provost Nellis, who could not be here tonight, but certainly sends his best regards. Before I introduce our very special guest, let me indicate to you that I am David Griffin. I am the chair of the Dorothy L. Thompson Civil Rights Lecture Series Board. And on behalf of that board, I would like for my colleagues and fellow board members, if you would stand, if you are in the audience. Most of us are coming back from dinner, so they haven't quite got here yet, but I do see a couple of the board members here, and I wanted to acknowledge them for their hard work and dedication. So thank you very much. Affirmative action. We have read about it. We have talked about it. We have our opinions about it. And yet, that particular topic is one that we still struggle to understand the history behind affirmative action and its true roots and meaning. We are privileged to have with us tonight someone who can put to rest, answer questions, and give some insight regarding affirmative action. Let me say to you that Associate Professor Peterson, Mark Peterson, is the chair of the Department of Political Science at Washburn University in Topeka. Associate Professor Peterson has been at Washburn for 11 years, and he has served 5 years as the chair of the Department of Political Science. A student of American politics, public policy, and administration, he had no particular expertise or interest in civil rights and race politics until two serendipitous events occurred in the year of 2003. The first was a project created in the university president's office at his university to do a lengthy interview with Washburn's alumnus, Arthur Fletcher. The other was involvement in a college faculty colloquium focusing on the famous Oliver Brown versus Topeka Board of Education case in commemoration of the 50th anniversary of the U.S. Supreme Court decision. The latter event led to an article jointly authored by Dr. Peterson and his colleague, Dr. Bob Beatty, on the contemporary community political environment, the Topeka at the time of the Brown case. The research of that article and the interview transcript prompted Dr. Peterson's decision to commit himself to producing a bibliography of Fletcher, an exploration of African American involvement with Washburn University in the decade after World War II. Please help me give a K-State warm welcome to our 31st Dorothy L. Thompson Civil Rights Lecture Series lecturer, Dr. Mark Peterson.
Okay, I'm going to try this unmiked to see if those of you in the back corners of the room can hear me, okay? I think that if I actually engage one of these electronic devices, you'll all flee the room from being blasted out. So let us take care of that business first. Okay. Well, I appreciate the opportunity to talk to you tonight about this gentleman, about what he did, about the heritage of what he did, and about some of the things that happened that didn't necessarily have a lot to do with Arthur Allen Fletcher. Some of you may recall a couple of months ago now, a gentleman named Eric Holder, the new Attorney General of the United States, gave a speech to the employees of the U.S. Department of Justice during African American History Month. It was widely covered in the press, and note was taken of the fact that Mr. Holder said we are in fact a nation of cowards because we have refused to recognize a central fact of American life, which is that 50 years and more after the Brown versus the Board of Education decision, we are still in many ways a highly segregated country. And his point was made when he observed, if you don't believe that, visit most public areas on a Sunday. We have learned to be cordial, to mix well and behave nicely, to show appropriate deference to individuals who have authority but have an otherness from us. In our work environments, from 8 to 5, America is a highly integrated society. After 5 and on the weekends, we fall back into those categories that define us in ways other than knowledge, skills, and abilities, for those of you who are public administration aficionados. Arthur Fletcher spent a good deal of his life striving to overcome those things, but he was a realist. Art believed that it would take much longer than his lifetime and much more effort than he could muster to overcome it. And I would suggest that Mr. Holder has probably put an apostrophe or an exclamation point on those feelings. I like to think that the work that I'm doing may move us down the road towards resolving some of those issues. As Dean Griffin pointed out, I don't come to this by training or predilection. It was serendipity that brought me to the topic of race. And I feel, in some senses, honored to have had these opportunities. And the person who was probably the provocateur in all this is this gentleman. Arthur Allen Fletcher passed away in July of 2005 at the age of 80. At his memorial service in Washington, D.C., he was eulogized by many, including his successor as chair of the U.S. Commission on Civil Rights, Mary Frances Berry, and the controversial Reverend Jeremiah Wright, who used as his theme the story of Jeremiah, the biblical figure who spoke truth to power but was ignored and punished for his efforts. I think that there was some intellectual insight at work as Dr. Wright crafted his words. At the time of his passing, Mr. Fletcher had faded from public life. His last hurrah came during the 1996 Republican presidential primary season when he broke with Kansas's leading elected official of the time, U.S. Senator Robert Dole, who was seeking and would ultimately capture the party's nomination. Fletcher repudiated his support for Dole and began his own race for the nomination. The rupture came over the party's and Dole's rejection of the signal effort of Arthur Fletcher's life, his determined, never-ending advocacy of the economic and educational civil rights policy of affirmative action. Fletcher is probably not known to you, or most of you in this room tonight. That's to be expected, because he falls into that twilight world of the nearly great and nearly famous, which has become the fate of so many talented men and women of the post-World War II era, as our society has grown from a mere 132 million in 1940 to the 305 million that we are today. He contended that the first great epiphany of his life came in 1937, when one of the legends of the early civil rights movement, a friend and advisor to Eleanor and Franklin Roosevelt, Mary McLeod Bethune, spoke to African American public school students in Oklahoma City during that spring on a national tour of educational and training facilities for young people of color that had been undertaken at the direction of the White House. She spoke of the need for diligence, dignity, and dedication for young people as they advance their own prospects and the prospects of the race of African Americans. Art felt that this was a calling. Soon after, his family moved to Fort Riley, Kansas, where his father was a trooper in the U.S. 9th Cavalry, the famous Buffalo Soldiers. And there in Junction City, he began his educational and sports career. I could tell you the story of Fletcher's youth here in Kansas, but that would take more time than has been allotted, and I want to get on to the discussion of affirmative action. So let me just say, Fletcher became the first African-American all-state football player in Kansas history, playing for the Junction City Blue Jays in 1943. He was also a standout in basketball and track. He went on to serve in World War II as an MP in Patton's Third Army. He was severely wounded by small arms fire in early 1945 and was sent home to the States to recuperate. In 1946, after being barred by his color from playing college football in what was then the Missouri Valley Intercollegiate Athletic Association, informally known as the Big Six Conference, for those of you who are sports aficionados, that's Nebraska, Kansas, Missouri, Oklahoma, Kansas State, and Iowa State. And discovering that although he had a scholarship, no suitable housing would be available for his family at the University of Indiana in the Big Ten, he found his way to Washburn University. There he earned a BA in social science and became a small college all-conference standout football player. And it was at Washburn that Fletcher discovered politics and formally became active in the Republican Party. It's the latter point that directs us towards affirmative action. Kansas African Americans who were politically active in the 1940s were largely Republicans. For many, it was the simple reality that Lincoln had freed the slaves, and Lincoln was a Republican. Ergo, these citizens preferred to be a part of the party of Lincoln. For others, there was the recollection that Democrats had been the pro-slavery party, dominated the politics of the neighboring states to the east and the southeast, and from a political realist point of view, had no influence in Kansas politics. Kansas politics has, for virtually all of the 20th century, been Republican politics. While Roosevelt had forged urban coalitions of ethnic, African American, and unionized labor voters in the rest of the nation, the Kansas Republican Party had created a space for African Americans. Outstanding members of the African American community like attorney Elisha Scott, who was the father of Charles and John Scott, Washburn-educated attorneys who would argue the Brown v. Board case in federal district court, were active Republicans who commanded enough respect from men like Senator Arthur Capper, Governor Frank Carlson, and State Supreme Court Chief Justice William Smith that they were able to obtain favorable patronage and assistance for young protégés. In addition, most of the young African American men who were at Washburn in those immediate post-war years were highly sensitized to race, having served in a military that was vastly different at the end of the war than it had been in the beginning. They were in school because of the GI Bill of Rights and fully expected to have and hold a place at the American table, unlike anything their predecessors had experienced. The U.S. Supreme Court had begun to undo Plessy and Jim Crow with cases like Sweatt versus the University of Texas and Sipuel versus Oklahoma. Wartime propaganda had aimed to play down segregation and race inequality, both to keep tensions down during a time of national sacrifice at home and as an effort to deny the fascists and later after the war the Soviets opportunities to score their own points against America's race hypocrisy. Roosevelt had ordered equal employment opportunity in federal employment during the war, and President Truman in 1948 issued his Executive Order 9981 to integrate the U.S. military. In this heady time, Fletcher found that his athletic prowess, attractive young family, and diligence in pursuing his studies attracted support from leading members of the moderate white community in Kansas's capital city. It was Price Woodard, later to become Wichita's first African-American mayor, who introduced Fletcher to party politics while they were students at Washburn. In 1954, Fletcher went into Kansas's southeastern counties with $5,000 in campaign funds and a $75 per week salary to mobilize a heretofore electorally inert population of African-American voters for a young, iconoclastic Republican gubernatorial candidate, Lieutenant Governor Fred Hall. The 17,000 new votes Fletcher got was not the total margin of victory for Hall, but it was a significant contribution. Hall gave Fletcher a high visibility job with the State Highway Department and pressed forward with his commitment to see the establishment of an effective Fair Employment Practices Commission to address grievances regarding racially discriminatory hiring practices in Kansas. During his 2-year term in office, Hall managed to give offense to powerful interests in his own party. This led to the most unusual circumstance of the incumbent losing in the primary election. When he attempted to pull off the famous triple play to become a state Supreme Court justice at the end of his term, after having lost that Republican primary in the summer of 1956, his political stock fell like a stone. Fletcher, who had his position by Hall's patronage, was out of a job and within another couple of years out of Kansas. He took his family to the West Coast, experienced some truly awful moments, some closely associated with Kansas connections who gave him poor references as a result of his relationship with Hall. Nevertheless, he worked for the Nixon Lodge ticket in 1960 in California, earned a California teaching certificate, became a community organizer and entrepreneur in the Bay Area, and was tapped by Washington state officials to direct a Great Society community development effort in East Pasco, Washington, which isn't a community but an area of the town of Pasco, Washington, up on the Columbia River, in 1965. Those efforts, which focused on community self-help, economic development, and entrepreneurialism, gained even wider attention when a cadre of local junior college students and members of the local African-American community urged, supported, and campaigned for Fletcher as he ran for Washington's office of Lieutenant Governor in 1968. When Fletcher beat a widely known sports personality in the Republican primary to be the party's nominee, the incumbent governor, Dan Evans, eagerly embraced him as a running mate, and the Nixon presidential election machine took notice. Shortly after the November 1968 election, after the 1968 election season ended, the Nixon White House was trying to get Fletcher into the administration. After he was offered a couple of different positions that he rejected, the position of Assistant Secretary of Labor was offered to him. Fletcher made an appointment with the new Secretary of Labor, George Shultz, who may be known to some of you as Secretary of State in Ronald Reagan's administration. Fletcher told of how Shultz proposed to make him responsible for U.S. wage and hour standards, and he countered that he would take the job if there was a potential to really create economic opportunities for African Americans. The two of them decided to move the Office of Federal Contract Compliance, or the OFCC, under the jurisdiction of the Assistant Secretary, and Fletcher had the job that launched his national prominence as the father of affirmative action. Within weeks of being sworn into office in February 1969, Fletcher's staff put together and received White House approval to go forward with a revision of what had been coined in the Johnson administration as the Philadelphia Plan. Excuse me a moment. This plan was targeted on a metropolitan statistical area which had a dramatic story of liberal labor activism and profoundly poor race relations. No city in the country had stronger union power over labor conditions and terms in industrial, service, and construction fields. In 1970, the population characteristics of the city of Philadelphia had a starkly divided racial composition. The self-identified white population of the city was 1.95 million. was 65.6%, while the African American community was 33.6%, or 654,000 individuals. And just to put that in a little bit of perspective, the proportion of the overall national population for a number of decades has been in the neighborhood of 12 to 12.5% African American. So nearly 3 times as many African Americans lived in the metropolitan statistical area as would be the average nationally. They could be a powerful political force. Nationally, the construction unions were a particular area of interest and focus for the Nixon administration because of the power of labor leader and arch nemesis of Republicans, AFL-CIO President George Meany. In 1967, according to Dean Kotlowski, African Americans made up just 8% of construction trade unionists, and out of a brotherhood of 330,000, the plumbing, sheet metal, electrical, asbestos, and elevator trades had only 1,400 black members. That's a national brotherhood. In Philadelphia, Anderson reports that at the time of the imposition of the Nixon version of the Philadelphia Plan, the iron workers had 850 members, of which 12 were minorities. Plumbers and pipe fitters had 560 members, 3 African American. Out of nearly 2,500 union members in the sheet metal trades, elevator constructors, and stonemasons, none were African Americans. Nationally, unions argued that many minority workers were union members, but the truth was that they were part of the unskilled common labor component of the organized labor force. 2 things worked against those who wished to move to skilled status. First, the standard practice of the unions was that applicants needed to be recommended by 2 or 3 current skilled union members holding journeyman or higher classification. Those recommendations most always went to sons, nephews, friends, and the children of close associates. Given the strong ethnic identities of the city's various immigrant groups, the prospect of cross-cultural personal bonds equal to those of family and background were small. Second, changing one's status from common laborer to skilled meant that all seniority was given up. For a young person just starting out, this was not such a hurdle, but for a laborer with more than just a few years of experience, the sacrifice of those years could be significant. And the loss of seniority would mean that in a slow or recessionary times, layoffs and cutbacks would be the lot of those who had made the switch, since position retention was entirely a function of seniority during economic downturns. As the assistant secretary in charge of OFCC, Fletcher would control the labor force composition in all construction contracts involving federal money amounting to $500,000 or more. He took the policies of the previous Labor Department administration under Lyndon Johnson's Secretary Willard Wirtz and put some rather small and dull teeth into them. The previous Democratic administration, for fairly obvious political reasons, had chosen not to confront organized labor with policies that would satisfy the minority elements of the party to the desired degree. Instead, the Johnson version of the Philadelphia Plan declared that opportunity and fair employment for minority workers on contracts and projects funded with federal dollars was the desired goal. So-called jawboning and public relations were the preferred enforcement methods for LBJ's administration. Not so with Nixon. The urban race-based upheavals that had been plaguing American cities during the 1960s and that had intensified in the wake of Dr. King's and Senator Robert Kennedy's assassinations had been politically horrifying. While there was considerable anti-black hostility abroad in the country, there was also considerable sympathy for the obvious economic disadvantages that beset the nation's communities of color. Nixon believed in the peace potential of the rising tide that lifts all boats. That had been a favorite theme of President John Kennedy. At the start of his administration, urban advisors like Daniel Patrick Moynihan had Nixon's ear. Politically, the concept of a more aggressive program of fair employment, already labeled by the Johnson administration as affirmative action, was irresistible. The unions despised Nixon, African Americans nationally were not enthusiasts for Nixon and the Republicans, but there were moderate Northeastern Republicans like Hugh Scott, Nelson Rockefeller, Jacob Javits, the Senate's only African American member at the time, Edward Brooke, who was a Republican from Massachusetts, and Westerners like Tom Kuchel from California that had good relations with prominent civil rights leaders. The potential existed to make some headway in co-opting and recruiting African Americans to become Republican supporters. But most importantly, as the historian Hugh Davis Graham has suggested, enforcing affirmative action represented a serious opportunity to drive a hard, sharp wedge between two pillars of the Democrats' critically important New Deal coalition: organized labor and urban African Americans. With this complex and deeply Machiavellian construct in mind, the Nixon White House gave Fletcher the writ to proceed with a plan that called for goals and guidelines for improving the numbers of African American workers in good-paying skill positions on federally funded contracts and projects in the Philadelphia area. From the outset and down to the current period, those who have opposed affirmative action have shouted that such plans constitute numeric quotas. For reasons both obvious and subtle, quotas are quickly construed by the public at large as un-American and wholly out of keeping with notions of competition and individual initiative and success. While Fletcher always, and in the beginning the Nixon White House as well, adamantly argued that the Philadelphia Plan as they promulgated it was meant to move employment towards ranges that approximated the racial classifications of the larger population, and that there were no hard and fast requirements, rather a desire to see progress and improvements moving towards that goal, the unions and people antagonistic to an economic approach to solving racial problems argued just as adamantly that this would lead to the hiring of unqualified minorities simply to fill numeric quotas, that it was undisguised union busting, and that at base affirmative action was going to take jobs away from qualified white incumbents and give them uncompetitively by government order to unqualified minorities. It was this last argument that set in motion the groundswell of antagonism to a concept that was born of the purest motives with a sincere intent to accomplish the constitutionally enshrined concepts of equal opportunity and redress of grievance. Lyndon Johnson had pointed out just 5 years previously in a famous commencement speech at Howard University, quote, "You do not take a person who for years has been hobbled by chains and liberate him, bring him up to the starting line of a race, and then say, 'You are free to compete with all the others,' and still justly believe that you have been completely fair." In short order, in the months and years following the implementation of the Philadelphia Plan and 26 similar metropolitan plans, the country's response virulently rejected the past president's assertion. While the Fourth Circuit Court of Appeals validated the Fletcher-enforced Philadelphia Plan, and the Supreme Court showed no interest in taking the issue up on writ of certiorari, the antagonistic response from Southern conservatives, unions, and Republican strategists within Nixon's own circle soon persuaded the president to begin to give affirmative action less support and little attention. By mid-1970, George Shultz had been promoted to become the director of the new Office of Management and Budget. James Hodgson, who had taken over the secretary's position, supported Fletcher, who continued to serve. The Department of Labor's own gloss on the progress of these affirmative action strategies on their DOL website reads, "Promotion of equal job opportunity became an ever more important activity of the department. Early in the Nixon administration, the department sought to knock down barriers to blacks seeking jobs in the booming, high-paying, and largely white construction industry by promoting voluntary minority hiring agreements between unions and contractors." Note the emphasis on voluntary. There were some impressive results, but progress was slow, the Department of Labor writes. To accelerate the process, the department adopted the Philadelphia Plan, based on a similar plan devised during the Johnson administration but never implemented. The Philadelphia Plan set a range of percentages of minority hirings with which contractors would be required to make a good faith effort to comply. When ordered into effect in September 1969 in its namesake city, the plan aroused controversy and heated opposition. Congress considered but rejected legislation to ban it. In February 1970, the department announced the plan would be extended to other cities unless they devised their own procedures for ending job discrimination in the construction industry. Developed with assistance from the department, hometown solutions were adopted in many cities. Under these plans, local contractors, unions, and minority organizations signed equal opportunity agreements covering private as well as federally funded construction. The Office of Federal Contract Compliance Programs coordinated these and other equal opportunity efforts and helped to improve their management. With the face-saving transition to the hometown plans, Fletcher was effectively done at labor. The next year saw him promoted to alternate representative on the U.S. delegation to the 26th Assembly of the United Nations. Fletcher would go from there to becoming president of the United Negro College Fund, where he's the man who signed off on the phrase that a lot of us remember, a mind is a terrible thing to waste, transmogrified by Dan Quayle a few years later. Fletcher would be in and out of government throughout the subsequent Ford, Reagan, and George H.W. Bush administrations, culminating in his tenure as chair and then commissioner of the U.S. Commission on Civil Rights, as an appointee of Bush's that continued on into the early years of the Clinton administration. Throughout those years, Fletcher served as a vigorous and voluble advocate of affirmative action, always prepared to defend it as a means to African American economic advancement and social empowerment. So what has become of Arthur Fletcher's child? In a most curious way, for formal public policy, the de facto and de jure realities of affirmative action are wildly divergent. In a de facto sense, affirmative action has become the norm in corporate employment, public employment, and to a pronounced degree in higher education and collegiate athletics. In contracting, public procurement, and economic development, minorities, minority-owned enterprises, and women continue to be recognized for preference of one sort and another, even though courts have rendered decisions that might be expected to severely limit or end such matters. Congress has not undertaken the wholesale repeal of landmark legislation like Title IX of the U.S. Education Amendments of 1972, which has proven to be such a boon to women's sports in higher education. Although specific minority set-asides for contracts and preferences for minority-owned small business and contractors were formally rejected by cases like Adirondack v. Pena, they continue to be encouraged and developed by contract procurement offices of virtually all executive branch agencies at the federal level and a great many more at the state and local level. America's Fortune 500 companies have discovered over the 40 years since the first enforcement of the Philadelphia Plan that affirmative action is good business. Minorities and women definitely approve of strong efforts in this regard, as do the moderate and left of center elements of the intelligentsia and the chattering classes. It is easy to understand why that approval remains positive among minorities and women. Consider the first slide, Melissa. Thank you. That I've entitled 2000 Census Comparative Datoid. Some of the students have already seen this. I won't do the whole shtick that I was doing this afternoon with the classes, but just let me point out a few things. The first line is the proportion of the total population of the United States as these defined groups comprise it. 69.2% of the 2000 population was self-declared non-Hispanic white, 12.5% Latino, 3.6% Asian, and 12.3% African American. Now, you have to think a little bit about this. The next line is the proportion of the population that is 25 years of age or older, so adults in the workforce, and retirees as well. 182.2 million individuals in the year 2000. What's the significance of these percentages? Well, if the percentage of the population associated with the group is larger than it is for the population as a whole, the presumption would be, since this is over 25, that it's a population that is statistically older than the average of the national population. Follow it? So I always say to my wife, you got that? So 73.4% of the non-Hispanic white population is over the age of 25. 10% is Latino, implying that they have a substantial, a disproportionately larger population under age 25, childbearing and children. The Asian American population is, for all intents and purposes, identical in the over age 25 category. And the African American population is 10.9% as composed to 12.3% for the population as a whole. So something that a lot of us sort of view as being obvious is demonstrated by the numbers. Hispanic and Latino families are growing at a faster rate than the average population, as are African American families. But Hispanic and Latino families are growing about 1% faster than is the African American population. The next couple of three categories define the relationship of individuals that we would consider to be job ready and able to join in the workforce with a set of skills and abilities that would serve from the standpoint of making a good living. Notice that the non-Hispanic white population, once again, is substantially better educated. And proof of what the press tells us all the time, Asian Americans really are very diligent, almost twice as many as their proportion to the total population have educations with a BA or better. Then come down, let's see, can we scroll it a little bit? We've cut off the last line, which I really want to get to. No? Okay, well let me just tell you about the last line since our screen is a little small for the data. I took a look at median household income. In 1999, the median household income in the United States was $41,994, according to the Census Bureau. And non-Hispanic whites made 108% of that value. So slightly better than the average. Asian Americans made 124% of that median household value. Hispanic and Latino household income was 80.2% of that median household value, and African American household income was just 70.1% of that value. So 1999, 2000, we're talking at that point 30 years post-affirmative action, and one might be able to make a fairly good argument that perhaps there is still a need to make some space at the table, to provide some opportunities. I have excluded data about women from it. I apologize for that, but I did want to emphasize the issue of racial and ethnic minority for the purposes of this paper. So that gives you a little flavor of what the data looks like. It's very crude, first cut. It's not really central to the research that I'm doing, but I thought it was important to sort of put some facts out there for you to chew on as we go along towards the end of this. From a de jure viewpoint, we want to go to the timeline slides. I'll just have Melissa sort of scroll this as I talk. What I've done is I've put together a listing of events associated with what one would consider to be the formal aspects of affirmative action. The first one up there that I want to draw attention to, which actually comes post Roosevelt's program of establishing a Fair Employment Practice Commission informally in the White House, is his Executive Order 8802 on June 25th of 1941. Note, Pearl Harbor hasn't happened yet. Bars war employment discrimination and establishes a committee on fair employment practice, formalizes it. Roosevelt had already been working along on that topic. So 1941, 28 years before Fletcher's affirmative action plan, we're beginning to see action at the federal level to establish a concept of affirmative action. From a de jure viewpoint, the erosion of the enforcement authority of government agencies like OFCCP has been steady and persistent in the years since 1969. Supreme Court cases dealing with affirmative action and its corollary concept of equal opportunity have been numerous and generally hostile to compulsory actions of governments, government contractors, and the actions that government contractors and private sector must take to hire and do business with minorities and women. One might argue that affirmative action has been reduced to the pirate Captain Barbossa's principle, that is to say, more of what you'd call a guideline than actual rules. The PowerPoint slides list the various formal fiats and the directives regarding affirmative action, including executive orders, congressional enactments, and the most prominent cases, including the Bakke case of 1978, dealing with the concept of reverse discrimination, and the last two decisions on the subject, Bollinger v. Grutter and Bollinger v. Gratz. In the last two cases, it is interesting to note that the Bush administration's position favoring the elimination of admission preferences at the University of Michigan, which is Bollinger, who was the chancellor of the university, was pretty lonely in comparison to the dozens of amicus briefs filed by former military commanders, corporations, and rights groups supporting the use of selection criteria used by the University of Michigan to provide additional opportunity for disadvantaged populations. Another phenomenon of the affirmative action story is the remarkable degree to which opposition and conservative politicians have benefited. Oh dear, he misplaced the last two pages of what it is he's talking about tonight. Not a good thing. It's going to make it interesting. I'll try and do this on the wing. The amount of the degree to which conservative politicians have benefited from affirmative action in the 40 years since the Philadelphia Plan, and the degree to which liberal organizations have benefited as well. Affirmative action has become a key set of words in the political discourse of the country in the same way that pro-life, pro-choice, or pro-gun, anti-gun have become mobilizing terms for our popular politics. It doesn't have a lot to do with reality, but it has an awful lot to do with mobilizing excitable elements of the public to join in to the cacophony of voices associated with it. Probably the best illustration, and it's a fairly awful one, of the effectiveness of the mongering that goes with affirmative action is illustrated by a now famous campaign ad that some of you have probably seen from the Jesse Helms-Harvey Gantt senatorial race in South Carolina in 1990. Melissa, you want to see if we can turn that on?
They had to give it to a minority because of a racial quota. Is that really fair? Harvey Gantt says it is. Gantt supports Ted Kennedy's racial quota law that makes the color of your skin more important than your qualifications. You'll vote on this issue next Tuesday. For racial quotas, Harvey Gantt. Against racial quotas, Jesse Helms.
Okay. Nice piece of political fear-mongering. In mid-September, the New York Times had the public opinion on that race tied, and both preferences within the margin of error, and there were 9% undecided as of September 23rd, 1990. At the November election, Helms, 52.6%, Gantt, 45.9%. amongst political opinion operatives, this is viewed as a classic attack ad, a very successful campaign for Jesse Helms. That's the kind of rhetoric that we have regarding affirmative action. It does not have much to do with reality, but it is probably one of the most effective tools for fundraising on both the left and right in American politics today. So what would Art Fletcher think of his child? Well, I think Art would be pleased. I suspect Richard Nixon would be pleased. Affirmative action has created a phenomenon in American politics that in their less Machiavellian moments, Nixon and his immediate advisors did kind of cotton to. There is no doubt that there is a middle class and upper middle class component of racial minorities in this country, especially African Americans, and they have begun to register and to vote Republican. And they own McMansions in the suburbs of Atlanta, and they drive Lincoln SUV Navigators, and their versions of Chip and Buffy play soccer and go ride ponies on Sunday. But it's a small group, but it does demonstrate, it would demonstrate to the satisfaction of Art, that economic opportunity can in fact lift people out of poor circumstances and move them into economically good circumstances. I think Art would admit, I think moderate Republicans would be reluctant to admit, that affirmative action does in fact account for this, but in a perverse way. Because essentially what happened was that creating greater opportunity in the economic system, particularly creating equal employment opportunity in governmental employment in the post-World War II era, led to lots of people who are now grandma and grandpa, but at the time were mother and dad, getting jobs that had seniority associated with them, that had good salaries associated with them, and them working their fannies off for years so that their children could go get a college education and become the dentist or the doctor or the tax accountant or whatnot. And so a lot of those new middle and upper middle class doyens of color owe as much to mom and dad's hard work and diligence as they do to effective governmental programs creating equal opportunity. But there is still a substantial population amongst minorities, amongst women, amongst the differently abled, who are still deprived from having an opportunity to take a seat at the American economic table. Corporations have recognized it. Most public agencies have recognized it. But the American public continues to maintain this cognitive dissonance that I spoke of when I began my monologue with you this evening. We believe, many of us believe, that Uncle Biff lost his job because they had to hire a black guy to take his position. Many of us believe that the fellow who lives down the street didn't get his advancement because they had to put an African American in a supervisory position at the plant or the office. The data strongly suggests the cases that have been filed complaining of discrimination, the suits that have been brought, do not support it. It ain't so. But the American public continues to believe it. When we ask people, do you believe in equal opportunity? They say yes, resoundingly. When we ask them, do you believe in affirmative action? They say, that's quotas, no. In point of fact, affirmative action has become a part of American society. We have become, and we continue to work towards, being an integrated working society. Where we have not gone is to break down those remaining social barriers that keep us from viewing everybody as us rather than the other. Are there questions? Yes?
Sir, to kind of keep going with what you were just talking about with it not being quotas, I mean, granted, nobody's not getting a raise because of this, or, because of that, like you said, but all things being equal, applicants to a college, 5 different people, all qualified, with affirmative action, does it go to that minority? Does it not? I mean, what would
Okay.
you say it is then?
All right, I think I follow all of that. Let me put it this way. Art, who I got to know and really admire and like, he was a very fascinating man. I asked him that question about the Michigan cases, which had been taken up on cert by the court before he passed. And I said, what do you think about this? And he said, well, let me tell you, there's an easy way to solve the problem of affirmative action in education. Get another chair. That's all it takes. I love to use law schools as an example because they're very mindful of quotas themselves. If you talk to a typical law professor, he'll tell you, well, we admit 100 students every year to our incoming law class. Why 100? Why not 105? Well, we've always admitted 100 students. We feel that that's what we can manage. They get a good education that way. We'd hate to become a diploma mill. Okay? I'll tell you as a college professor, the difference between having 25 people in a classroom and 26 people in a classroom is probably about 90 man-minutes of my time over the course of the semester for additional grading effort and so forth. Making a little more space is really all that is required. Why do they hold to that? Because exclusivity gives cachet to the degree and the school. We don't produce Harvard lawyers willy-nilly, because if we did, it would cheapen the brand and reduce the starting value of those graduates. Perhaps for the elite schools, that's a decent argument. But for tax-supported universities and colleges around the country, public institutions, it is a thin reed upon which to make a hard policy. And I think, Art was very clear and very right. So when you run into issues like that, my suggestion is, first of all, who's motivating the argument? Who's raising the case? And then dig in and find out what the deal really is. It is not unusual to have a situation, for example, in employment, where a minority will be selected for a position where there is an open space and there are people competing for it. That may be because the policy of the company, as many Fortune 500 companies do, for example, is to move towards legitimating an appropriate distribution of groups within their workforce. They want to look like America. They want to have people working for them that reflect their customers. And so when it comes down to one guy who scores 85 on the competency test and another guy who scores 85 on the competency test, and one of them is a minority and one of them is white, the company's policy is we're going to pick the minority individual, and we're going to do that until we have achieved the balance that we are seeking for our corporate purposes. The white guy may be upset about it, but he didn't get screwed out of a job. He lost a competition. In any other environment, we walk away, I bowl a 275 and my buddy bowls a 280, I lost the game. I play on a softball team and the other folks beat us by a score of 14-12. I shake their hands, congratulate them on a good game, go drink a beer and plan on playing another game next weekend. I don't accuse them of being unfairly athletic or all buddies and so they fudge on the rules. I lost the game. But when it comes to one's economic well-being, we have a tendency to take it hard when we lose things. And one of the hardest things to take is to come to the recognition that in this particular scrum, under these particular circumstances, you weren't the talent that won today. Now, the shibboleth about the guy who gets bumped out of a job in order to accommodate a minority is bunkum. There's almost nothing evidentiary to suggest that people are fired out of jobs as incumbents in order to provide an opportunity for a minority. And really, when you look at the affirmative action plan that Fletcher put in place and was working towards during his tenure in the Nixon administration, all they were asking was for the trade unions to create, as I was suggesting about education, some spaces for new apprentices of color in those trades. The notion being that if they passed through the apprenticeship and earned their journeyman cards, then they would join the pool of qualified laborers in that union, and presumably in good economic times, as the least senior members of the union, jobs would come to them, and they would rise in seniority and ultimately take their place within the body of the union membership. But when the roster down at the union hall says O'Reilly, Shaughnessy, Hanlon, and Kelly are available journeymen today, and you don't see Green or Brown or some other non-ethnic name on the list, it tells you something about the close-knit nature of the union that belies the argument about being fair and open about things. I hope that answered your question. Anybody else? Yes, sorry.
This kind of speaks to her question and to your answer, that it sort of implies that there's a lot of this going on where it's simple, the simple idea that a less qualified person is being hired into a job over a more qualified person. That happens less and less these days, although it is legal under Kansas law. Kansas law says that it shall not be an unlawful practice to hire somebody in order to create changes or balance or improve the balance of race, gender, ethnicity, gender, and so forth. But it rarely happens these days. The Office of Federal Contract Compliance Programs that you mentioned numerous times early in your talk, the OFCCP enforces Executive Order 11246.
Right.
And the definition of affirmative action by the OFCCP is this, is that if you're an employer, let's say you have a federal contract, you're an employer at Fort Riley, or you somehow federal money trickles down in, and the OFCCP has jurisdiction, here's the definition of affirmative action, is that you will do workforce analysis. You will analyze your workforce, typically on an annual basis, and you will compare within certain categories what that workforce looks like compared to the workforce that you draw from.
Right.
And that's called utilization analysis. And then the second step is to identify problems where you might be underutilizing females or minorities in certain categories.
Right.
For example, protective services, fire and police. If you look at that category and you don't have any minorities in that, and you have 300 people that are in that category, then problem identification kicks in. Here's a problem, and then voluntary, what do they call them? Just solutions after you've identified possible areas. They're voluntary solutions where what can we do to remedy this problem?
Right, and you have to make a best effort.
That is the definition of affirmative action by the OFCCP, the Office of Federal Contract Compliance. Not what she's concerned about, and not really what you described as why not give this job to somebody to remedy past discrimination. Now, that's my one thought. I wanted to kind of develop that into a question for you.
Okay.
Because this battle is ongoing, and the lines are drawn on either side of what you described. The typical person thinks affirmative action, quotas, and that's not really typically what it's about.
Right.
You mentioned Adirondack versus Pena.
Right.
Pena was the Department of Labor secretary under whoever the president was.
Transportation.
Secretary of Transportation.
Secretary of Transportation.
And so under the Department of Transportation, there's a thing called DBE, Disadvantaged Business Enterprises.
Right.
It was modified in 1988 to include women-owned businesses and something else. So you've got the Federal Aviation Administration, the Federal Highway Administration, and the Federal Transit Authority, and these programs apply. Adirondack was a contractor that didn't like the fact that this program was designed to encourage the participation of minority and women-owned businesses to participate in some of these contract dollars.
Right.
And so in the old days of these programs, prior to Adirondack in 1995, there were actual sort of quotas where if we have a big job and it's funded through these federal DOT monies, then 9 or 10% of those dollars have to go to minority and women-owned
Right.
firms.
Right.
After Adirondack,
Set-asides is what they were.
well, set aside, after Adirondack, those went away. And all of those programs, that Adirondack said that it's the narrow tailoring thing. This program has to be narrowly tailored to meet the compelling governmental interest of, and our compelling interest is to try to spread some of these contract dollars around to minority businesses who otherwise could never get their foot in the door because of cronyism and you know, if you're my brother-in-law, I'm going to give the contract to your company,
Right.
not to another.
Right.
And so after Adirondack, then the Q word went away.
Right.
You cannot use the Q word quota or any mention of numerical preferences, and now we have goals.
That's right.
And so if those contracts come down through the DOT, whatever operating administration, then you have a goal, and if you don't quite meet that goal, then you kind of have to prove that you made good faith efforts to do it. But what's happening is it's actually winning contract dollars for minority and women-owned businesses.
Yes.
So in my mind, that's a good thing, and it's not as heavy-handed. And so here's my question finally.
Okay.
Every time I open my mouth, that happens. I finally get to the question. After Adirondack, the courts upheld these race-based and gender-based programs in Adirondack, and in subsequent, I think, Adirondack 2 and 3. So the courts have upheld these, and we've got these programs that are designed to, and this is affirmative action. It's not hiring Fred over somebody else,
Right.
the way most people think. And the courts have upheld these programs. So now, the people who are philosophically and ideologically opposed to these programs have taken the battle elsewhere. And this is what I want to ask you if you've heard anything about it. In the state of Washington, an entity called the Pacific Legal Foundation. The Pacific Legal Foundation is an organization of a lot of attorneys, and their whole reason for being is to roll back any kind of affirmative action, to roll back attack it in the courts and roll them back and get rid of them.
Right.
And the last I had heard, they'd taken the state of Washington DOT, Department of Transportation, to court and saying, your programs don't meet the test, don't meet the requirement. And the last I had heard that the Washington State DOT was kind of on the ropes on this, that it may be going, and then if one victory in that court, then they're thinking maybe they can roll it back all the way across the country. And I wondered if you'd heard anything about
I have
Washington
not followed
case.
the recent developments that closely. I'm surprised, I guess, to hear that the DOT is that the state is having a difficult time making its case in that regard. I hope they don't prevail.
Well, what they look for is things where you didn't quite get it right,
Mm-hmm.
and say, here, this doesn't comport with what the courts have said that
Right.
it has to do.
I think my answer to that would be that the U.S. Supreme Court has had the opportunity, especially with the shift towards conservatism on the court, to really step in with heavy feet and undo some of this, and they have resisted. The two Bollinger cases did not turn out to be the victories that conservative advocates were hoping for. As I pointed out, the Bush administration wound up being pretty lonely in its arguments on that case, and the court heard it. So my expectation would be, particularly with the shift in popular politics that's taken place with the recent election, as was it Finley Peter Dunn said, as all of our American government textbooks tell us, the court hears the electorate. That it's unlikely that if this becomes a federal case, the Supreme Court is going to be particularly heavy-handed and roll this stuff back. But they may prevail at the state level. I don't know.
Considering that they've upheld it thus far, they may just give the state of Washington, the court may give the state of Washington an opportunity to correct whatever it is that doesn't.
Yeah, or give it a federalist pass and let them do it, but not take it up on certiorari. You had a question? Yes, ma'am.
I just had a comment, which is that, and I know your talk had a somewhat different focus, but I think many people do not appreciate just how important affirmative action has been for women, particularly in the 60s and 70s. It made a tremendous difference. And I have memories of applying for my first job at Eastern Kentucky University, and I got that job, I think, because they knew that they needed to hire women as well as men.
Yeah, and in response to that, I would contend that affirmative action has probably been more effective for women than some minority groups, and you can sort of tell it. This room is actually a little bit out of sync with the national trend, but the trend in higher education, for example, is that women now outnumber men in undergraduate institutions in this country, and by a fairly substantial and growing percentage. The door has been opened, and women have walked through. They've taken advantage of the opportunities, and one hopes that we will all continue to be advantaged in the future. There is space available, I think. Yes?
Sir, using your example earlier of both individuals scoring an 85, both equally qualified, one being a minority, one not being a minority, that the job going to the minority, you said, that's just fair play the way it is. How would you respond to accusations that on the individual level, that is discrimination in of itself? The fact that this individual got the job because he was a minority, but the other got it because he wasn't, to fill a niche. I understand what you said before, but there are people who feel that you're just trading one form of discrimination for another.
Undoubtedly. I mean, discrimination, the definition for the term to discriminate is to make a choice between things. A decision to hire him over her is a discrimination. It is a selection. I don't know why, but I felt that he interviewed better, and I think he'd be better for our company. She seems a little reticent to be as aggressive as someone I want in my sales force. They're both got great college transcripts, but in terms of the person I'm looking for, he wins, she loses. She will feel ill-served by that decision if it was her desire to go to work for Ajax Sales Corporation, the company that she interviewed with. When she goes home and she gets the letter in the mailbox or the phone call from the human resources individual who says, Molly May, I'm sorry, but we're not offering you the position, she is going to say, as is our human nature to say, damn, I wonder what he had that persuaded them, I really hate losing. I'm sure the game was rigged. They were never going to hire a girl. Something to deflect the loss away from oneself and find something that you can hang it on. It's human nature. The point that I'm trying to make is that those decisions will get made, and if the company or the agency, the contractor, whoever it is, has said, essentially, we're trying to bring some balance that reflects the surrounding population and skill set that's out there, know in advance that if I'm confronted with two equally qualified candidates, I'm going to discriminate in making my choice. I am going to make a decision, and it's likely not to benefit some of these job seekers. And it may be that they are part of the majority population, because it is my policy for the moment and until I achieve the balance that I'm looking for, that I'm going to give preference to those individuals who are minority and equally skilled. or better skilled, comparably skilled. I'm going to do that. Yeah, I'm going to make that choice. I got to make a choice. I can't hire everybody. I've only got one position available. That's the fundamental difference between the market and education. But yeah, it's going to happen. And some people are going to be offended by that process. But it's not a sue and offense. Yeah. Yep.
My question was, what would you say to, I believe his name is Ward Connerly, if you were to have a conversation with Ward Connerly, what would you say to him? And what do you think, if Fletcher was still alive today, knowing that Ward Connerly is African American, what do you think he would say to him and his opinion on not being for affirmative action?
I think that Fletcher and Connerly would, first of all, probably butt heads because of ego. But if they could get past that, they might, in fact, sort of agree with each other. Connerly is, very much a highly individualistic, bootstrap kind of guy who believes that, essentially affirmative action does the community no good because it makes Whitey think that we're all here because we're not qualified. We just, they threw us a bone. We got a break. And Connerly doesn't like that. He wants it to be highly competitive, really socially Darwinist in its approach. Fletcher and Connerly, if they could get past, the alpha male issues, might, in fact, have a resonant conversation with each other. Connerly has learned to demagogue the issue. He's learned to take his position and turn it into something that is probably larger than what he really at heart intends, because it attracts interest and support and money and the rest of it. Connerly is completely laissez-faire. My personal perspective on it is, as we have seen in this current economic situation, a completely unregulated, market-oriented approach to things doesn't turn out well. It doesn't turn out well in a social context. You can't leave masses of constituents on the road of failure and call it a success. I think probably Ward and Art could probably agree on more than they disagree. Yeah.
In the examples that you gave before, sorry to bring this back up, but you said like in bowling or baseball, one person wins the competition and they win and we go on with it. The problem that I see with that analogy is that those skills, baseball, bowling, those are skills that the person can work on, they can improve on, they can practice it. Sure. As skin color is something you're born with and cannot work on or improve on or change. So in an ideal society, people are not like judged because of their skin color. It's just like their characteristics and how well they work and all that good stuff. But this is not an ideal society where people are not judged by the content of the character, but actually by the color of their skin. As you gave in your example, you said that even though they're equally qualified, the person with that's a minority will get the job because of the color of their skin, which is exactly what Martin Luther King Jr. worked against. So it seems kind of contradictory. Okay. But my question is, is that do you believe that the system that we have now with the quota and how people choose who works based on color of their skin, etc., do you believe that's the best system? Maybe a process where the gender or minority or skin color is not known, maybe that would be a better process? Do you believe the process that we have now is best and works best with this?
If the objective is to achieve, as I said before, if the objective is to achieve a workforce that is reflective of the surrounding society, then the answer to the last part of your question is no. I want to work to have a diverse workforce. I want to have a workforce that says to my clientele and customer base, I'm a company that looks like the world that you live in. I have people who work for me of all shades, ethnicities, whatever. If I don't have that, I need to work towards that. I need to try to get that job done. That doesn't get done necessarily in a colorblind environment. So I think that, essentially wiping away distinction simply reduces the ability to make what I would consider to be really reasoned and intelligent decisions to serve the circumstance that I'm trying to cope with and deal with, okay? You brought up the term quota. Quota, schmota. Quota is a term that's used like the red flag in front of the bull. This has been pointed out here earlier. The way the courts have gone, the way the rules are written, the way most agencies and corporations try to do it, there's no quota. What there is an effort to move towards a goal and make a good faith effort doing it. So, what I hope happens in the long run is a couple of things. One of them is, sort of purely, altruistic, philosophical, whatever you want to say it. I hope that someday we'll all live in a society, as I said at the end of what I was saying before, where there isn't any other. There's just us. I made this comment in one of the classes that I addressed earlier today. I remember this comment, and I remember the reaction of my pro-seminar professor when I brought it up. The famous comedian Whoopi Goldberg said some years ago in some context in which I heard her, she said, well, the way in which we will solve the problem of race in this society is when we're all butterscotch babies. The other will disappear when we stop classifying people by skin tone or nose shape or hair or accent or surname, and we simply start accepting the fact that we're Americans or we're people, which might even be a better construct. It's a curious thing that during the Second World War, the propaganda machine of the Roosevelt administration worked with great and intense vigor to do just that. There are some wonderful articles out there about turning, for example, I remember the title of one of them is How Joe Louis Became G.I. Joe. All about how the U.S. military used the boxing champion Joe Louis to demonstrate what a wonderful and egalitarian thing the U.S. military was becoming in the unified effort to fight fascism. Much of what motivated those young men at Washburn in the late 1940s after the war, when they were there on the GI Bill, was a belief in the thrust of that propaganda. The government spent a lot of money and a lot of time working really hard on the notion that, by God, we're all in this fight. We all put our pants on the same way in the morning. We're all committed to driving fascism off the face of the planet. We are all committed to victory in this war. And it was repeated with such intensity and such a fervor that people actually began to believe it. In many respects, it's unfortunate that we relaxed the effort in the decades after as we became focused on self-aggrandizement and enrichment and getting ahead and building a wealthy middle class and all the rest of it. So I don't know if that really addresses the question that you asked me, but in point of fact, the notion of affirmative action as it is, the point of what I've been trying to say is the notion of affirmative action as it is conveyed for political purposes is not reality. It's a mode of expression and an approach to the issue that is designed to stir, inflame, stimulate people to, primarily send money. Jesse Helms' commercial not only got him votes at the polls, it got him buckets full of campaign money from folks who said, yeah, that happened to my Uncle Ralph. He lost his job. I'm sending Jesse $5. And then they turned out and voted as well. It spurred a public reaction. It isn't reality. It isn't truth. But it moves us at some relatively more primitive level It's an easy thing to say. It's easy for all of us. You know, when we face adversity, when we face a failure of one sort or another, we look for a scapegoat. What better scapegoat than that guy who doesn't look like me and I don't know, and don't really want to know, and I can blame him. And in doing so, I don't have to worry about my personal shortcomings. Yeah.
You say the objective of affirmative action is to open seats at the socioeconomic table to people who would not otherwise have it. But in my little experience, so many of those people who benefit from affirmative action are people who would otherwise already, like that small group of people who live in McMansions, minorities who've been able to send their kids to private school, people who are already well off. So it seems like, to me, the same people keep reaping those benefits.
Well, what I would say to you is, once again, show me the data. You know, the arguments about reverse discrimination have always faltered on the basis of show me the data. If you can show me significant numbers of people who are occupying positions of wealth and comfort simply by playing the race card in affirmative action, I'll take my hat off to you, but I don't think you're going to find them. I think you're going to find successful people who have engendered envy in others who are happy to say, oh, well, I know why he got the job. It was affirmative action.
Do you think it'd be realistic to like put socioeconomic, if to put like a background, or does that make sense?
I'm not sure I followed that.
Would
Try
it be
again.
realistic to target a specific group of minorities, people like first generation college students, things like that?
Oh, I suppose it could be done. I mean, when you stop and think about it for a moment, you know, the classifications that are up there, even though they're self-identified, are really pretty arbitrary. We could classify people by blood type. We could classify people by, the protein composition of the DNA on the 13th chromosome. There are lots of ways in which we could classify people. It is the nature of who we are, and this gets into the realms of sociology and anthropology that are not, my purview. But we identify. We identify by our ethnicity. We identify by our race. We identify others by those things. I suppose that we could, I'll bet you that out there somewhere in the world this actually happens. We could probably identify left-handers and right-handers. In fact, I think as I stand here and just think about this extemporaneously, I have heard, individuals who complain that I live in a right-handed world. If you think about all the goods that are out there that require manual control, they're usually right-handed. Lefties are a minority, and they have some issues. So we could just as easily, have an affirmative action program that creates opportunities for lefties versus righties. This happens to be an argument, and it sets off another whole path of discussion that we can't really get into tonight, that has to do with why African American is, we're in the vanguard, if you will, in this discussion, and why it remains a meaningful classification. And it has to do with one fundamental ugly fact of the American Republic, and that is slavery. And it is the fact that we established this nation with a constitutional authority not only to legitimize slavery, but to continue it after the founding of the Republic, to continue the importation of slaves for 20 years after the ratification of the Constitution, and to permit the ongoing trafficking in slaves and the maintenance of the institution of slavery for 80 years after the founding of the Republic. And that has established a class of individuals who have, I think, a legitimate intellectual right to argue that they have some rights to things that we need to take note of. Others have followed in that wake.
Okay, we're going to take
Yeah, it's getting late. Okay.
Okay, I have a fairly brief question. I think I can build a little bit on what the last question was. I'm sorry if
Right.
I put words in your mouth. I don't mean to. But she began by discussing the concept that affirmative action is, at its very, very basis, in place to open up seats at the economic table, if you
Right.
will, to
Right.
people who would not necessarily, under quote-unquote normal circumstances, make it.
Sure.
Make it to. In essence, the issue began with slavery, as you just stated, that automatic economic and educational disadvantage that these people were at just on an automatic basis. But it seems to me that affirmative action is a little bit outdated in the way it's addressing these issues. Because while the issue of poverty and this lack of access to these socioeconomic seats at this table, again, if you will, while that initially was an issue of race, so many generations have gone through that race may still play a factor now, but it seems to me that it's just socioeconomic status. It's just the fact that I am a first-generation college student, or I was born here, or this is how my family is constructed and how much money my family makes. It seems to me that addressing this issue when people start applying to make it into the workforce, it seems too late. And maybe this isn't exactly how I should be phrasing the question. Maybe this isn't exactly up your avenue. But why, in your opinion, why haven't we begun to focus towards education or towards the younger generations rather than waiting until people are applying for jobs to say,
Okay.
well, now we're going to take race into consideration? Because it seems to me it's not a racial issue anymore. It's a socioeconomic issue of generational poverty. And I would like to hear you address that.
Okay. First of all, I would tend to agree with some elements of what you just said. In the American educational establishment, I mean, one of the stories that I think that will be written about the last half of the 20th century by historians 50 or 100 years from now is that American public education was a remarkably powerful and effective thing. And if you stop and think about it in a minute, in contexts outside tonight's discussion, I think you can see it. How likely do you expect it is that your brothers and sisters who are in elementary school and middle school today will ever smoke? How likely do you think it is? Not very. You know where that inculcation of value took place? American public education. Smoking is bad. We've been teaching it to kids now effectively for about 30 years. And the number of people who smoke has now fallen to a core number that strongly suggests that people who smoke, have some sort of a pathological difference from other people. It's no longer habit or a disposition to be cool, because it ain't cool. It ain't cool in school. And the kids who do it are probably come from families that smoke, and we may one of these days, I suppose, discover that there's a nicotine gene or something. Similarly, American public education for the last 25 or 30 years has taught diversity. I have a little bit of experience from time to time with grade school kids, and when you go talk race to grade school kids, they don't know what you're talking about. They haven't a clue. Now, they do have, they develop an understanding of some of the icons of the racial struggle in this country, and they put Martin Luther King Jr. up there with other greats of contemporary American history. But they really don't have any awareness of race. I suspect that by the time kids who are 8, 9, 10, 11 years old today get into the workforce, a lot of the issues that we've been discussing tonight, if you were to be able to do a public opinion poll of that specific age cohort and ask them what are the most important issues in America, they're probably going to tell you that issues like we're discussing here tonight are completely off their radar. They're not likely to show up. So I think that education is changing, has been changing, and is effective at changing people's attitudes, okay? Now, having gone off in that direction. There was another element to what you were asking me that I wanted to address, and I can't recall what it is now. Do you? Oh, yes. That problems are more associated with socioeconomic categories. I'm a little bit ambivalent on that topic. I was having a conversation this afternoon with an individual, and we were talking about some gang violence that encroached upon her family and caused her to make a decision to relocate, to get away from it. Much as affirmative action is a buzzword politically, I think there are a lot of social pathologies in this country that we've gotten comfortable talking about as being attached to specific groups. Hispanics and Latinos and drug importation, for example. Southern whites and abuse of guns, and gang violence in African American youth. And there may in fact be, disproportionate relationships between those social morbidities and specific groups within, or specific elements of these groups we've been talking about tonight. But if you stop and think about it, there are white kids who are in gangs. There are white kids who buy into some of the thuggish aspects of rap music. There are Hispanic kids in gangs. There are Asian kids in gangs. If we started talking about socially undesirable behaviors amongst adolescents, it would be like taking a trip back to the 1950s when we talked about juvenile delinquency. And juvenile delinquency was generic. It didn't really have a racial quality to it. It was everybody under the age of 19, and you were all, bad kids. And the curious thing about it is that when we talked about it as juvenile delinquency, a generic problem of the age cohort of pimples and hormones, we rose up and did things about it. We organized our schools. PTAs took up the issue of juvenile delinquency. Policemen came and talked to parents about the signs of drug abuse or the influence of rock and roll in destroying your child's moral values. Somewhere along the line, it became politically useful to have that topic migrate. So now it's black gangs who engage in random violence. Really? Well, yeah, I read about that. But I read about white kids in gangs engaged in violence too. But we don't talk about white kid gangs. We talk about African American youth gangs. Maybe what we should be talking about is the problem of gang violence in adolescence. Maybe if we did that, we might have a way of engaging the entire society in dealing with that problem, rather than cutting it up into nice neat slices that allow us to sit at our suburban breakfast tables and say, isn't that awful, more black on black violence? Oh my. Well, it's their problem, not mine. It's all our problem. We all have it. Some communities may have it to a greater degree than others. I would argue that some communities have it to a greater degree than others because of some of the disproportionate aspects of what I just briefly touched on in terms of that census stuff. We do know that there are populations that have higher numbers of one-parent families. We know that we have higher numbers of children without adult supervision in some element, and some of it is socioeconomic. Clearly one of the things, as I said before, that would gratify Richard Nixon or Art Fletcher is that there are a whole bunch of people in the African American community who in the 40 years since the promulgation of the Philadelphia Plan have indeed captured the American dream. They clean up real nice and they make good livings and they're just like us. Well, except they're still African Americans and I'm worried about the value of my house since the family moved into the neighborhood. But they're nice people. And not only that, but one of them's on the Republican Central Committee in my county. So they're okay. And then there are those others who didn't capture that brass ring of capitalist economic success, and they're an entirely different story. Well, truth be told, there are large swaths of America's population who fall into that category regardless of the color of their skin or their ethnic background. And we ought to be really thinking about how to address that problem rather than trying to slice it and dice it.
Okay, we've got one question. I'll throw this one in right here.
Yep.
Just sort of an extension on the last question, but one thing that you mentioned in your speech was that in the business world, affirmative action has basically, it's been accepted as the norm.
It's good business.
And exactly, you said it's been accepted as good business to practice this. And as an extension to the last question, would it seem reasonable to think that we're, because of this conclusion that you've made, come to a point in our society where maybe we don't need such a policy anymore? Maybe businesses will realize that it's in their best interest to do this anyway, and it's not necessarily something that the government needs to force on the businesses.
Well, I'll drag up another Republican in this regard, Ronald Reagan, who said, trust but verify. I think it's a good idea to leave the laws on the books. It is human nature to take the low and easy road if the opportunity affords itself. And I think that this period of economic stress that we are in right now is going to be a challenge. You know, just quickly, and then I really am going to be quiet. Back in the mid-1990s, the Gingrich Congress, the Republican Congress with Bill Clinton in office, put through a massive change in welfare laws in this country. We used to have a program that was called AFDC, Aid for Families and Dependent Children, and much like, you know, affirmative action as a buzz phrase, AFDC got transmogrified into welfare queen. You know, the government was paying money to women who were laying down in sin and creating additional children just simply to increase the dole. Hogwash, but it made good PR. And on the basis of that, the Republican conservatives who had captured Congress with the '94 election set about to change social welfare. They created something called TANF, Temporary Assistance to Needy Families. And I used to be able to rattle off all the criteria, but the fundamental deal with TANF was you had a lifetime limit on access to welfare support. I think it was 60 months. You could come on to the system and take it in increments, but totally you could never receive more than 5 years worth of benefits. And they decoupled things like food stamps and Medicaid from welfare so that if you needed those services, you couldn't get it in one shot. You had to go shopping to find the resources. They made it more difficult to participate in the system. And the Republicans were absolutely thrilled with the result of TANF. They said it drove down the welfare rate in this country by, I think, 11 or 12% in a year or 18-month period. It put tens of thousands of able-bodied women to work in the workplace, leaving them wondering what they were supposed to do about things like child care expenses. But there were provisions in TANF to provide for that sort of thing. And it looked wonderful. It looked like, you know, these laissez-faire, Ayn Rand reading objectivists had succeeded in doing something that the Democratic establishment had resisting for years. And then at the end of the 90s, the market, the economy kind of went to hell. And we discovered that all of those women who supposedly had disappeared from the welfare rolls were suddenly in tremendously fragile economic shape. They had no resources and they had no fallback position. They had nothing going for them. And being last hired, they were first fired when cutbacks started happening. And we discovered that the great improvement had been a corollary level of increase of activity in the overall economy. It had nothing at all to do with changing the welfare system. In fact, changing the welfare system probably harmed the prospects of a lot of mothers and their children as a result. And the economic circumstance masked the fact. In this current recessionary period, I think it is entirely possible that Fortune 500 companies, and especially those outside of the world of stockbroking and finance, which have been equal opportunity firers as well as hirers, are going to look around and they're going to start constricting their labor force. And when they do that, I think that probably the places that will feel the pain the most are amongst the ranks of the least tenured, the lowest skilled, the least experienced individuals in the workforce. And many of those are going to be individuals who have gained the opportunity to participate because the system was opened up to them and they had an opportunity. They had a space made at the table. And if the table shrinks, like musical chairs, I think a lot of those people are going to find that they're going to get bumped off their chair. That may be just the luck of the draw, but I think we may have to be in a position to say, okay, as things recover, remember your social obligation as well as your commercial obligation. Okay? Thank you all for listening.
Let's give Dr. Peterson a round of applause.